All your questions answered. Easily fulfilled when there aren't any. Anyway, if I say anything today that gives rise to a question, pop it on. I think it was a proud record, every single Padlet question answered.
Where is it again?
If you go to announcements and go down about 4, it says Padlet for Judicial Review and Lectures.
Okay.
Yeah.
It says the 5th of February.
What's it showing? You don't have access. I'm sure that I set it. How about now? Yeah. Right, folks. Let's make a start. So, if you have your deadlines at your fingertips, you'll know that tomorrow at noon the marks and feedback from the first coursework on this unit are released. So, as ever, you are warmly invited to come and discuss your marks and feedback with me. There was another public law person shared the marking with me. So if you want to come and talk about your feedback, I suggest you email me, and I can make sure you go either to me or the other person who did some of the marking. I did most of it, and we moderated them together. Of course, your next essay is a problem question, or rather your next coursework is a problem question, but there are some general points, again, of basic legal craft, which will help you with any law writing that some of you still haven't quite got the hang of. Like quoting from judgments and statutes. Many of you seem to be allergic to this idea. I have no idea why, it's so weird. You see someone, instead of actually quoting, they give their own kind of slightly mangled paraphrase, which often misses out crucial points or is somewhat inaccurate. You just think, and this is absolutely what lawyers do, okay? If you read a skeleton argument prepared for a hearing, they quote copiously from judgments. A lot of you still seem to be really allergic to that. It was really weird reading the answers. So, and that obviously applies to essays, particularly and problem questions, big time. So that's can I just say that again, please, please? There are often quotes provided on handouts, lecture slides, etc. No, you prefer to produce your own summary of what the judge said. Guess what? You can't say it as well as the judge did. It's never quite the same, it's not quite as good, and you often tend to get it a bit wrong, which is why barristers and lawyers quote from judgments and from statutes. Okay? I mean, I said all this in relation to the formative, I think before the formative and after the formative, but it was still such a marked feature when I was reading the essays, and I was just left bemused. As well as some of you still happily ignoring all the material set for the learning cycle, reading a whole bunch of other stuff you've dug up from the internet somewhere, God knows where, not the learning cycle materials, still, I don't know, quarter of the essays, something like that, very weird. Anyway, I will be giving a special feedback lecture for which you can use obviously for all other essay-type questions on law that you write, and also quite a lot of it is applicable to problem questions as well, because it's basic legal craft stuff to help you write like lawyers. Okay, I know you know how to think like lawyers, you have to start writing like lawyers. Right. And it helps yourselves. I was talking with my wife and she said, but why? Because copying and pasting a quote is much easier and faster than making up your own paraphrase. It's actually, so it's quicker and easier, as well as 10 times better. So, just strange to me, that one. I'm sure you have your reasons. Maybe you can come and tell me if you're one of those people that you find written on your please quote.
Normally for me, if I cut down a quote, it's because of the word count. I'm trying to have
Right. Yes. So you don't want really lengthy block quotes. You want the bit of the quote that makes the point you want it for. So yes, skillful editing of quotes is good, but not paraphrasing, and not so skillful that you actually miss out. I had quite a few who kind of cut a quote right down to a few words and managed to brilliantly miss out the most important part of the quote by only having literally about 5 words of it. I get word count. I do get word count. But anyway, it's very important to come and get as much feedback as you can. So there'll be a lecture, there's your individual written feedback, and please also come and see me to discuss it. So, right. So this is the last Edition Review lecture. There'll be another recorded lecture on Wednesbury unreasonableness / irrationality for the next learning cycle. I'm hoping, but I'm not that sanguine, that you've listened to the recorded lecture on Procedural Impropriety 1. No? Any other people brave enough to say no? I was kind of not expecting that everyone would. Any other no's? No's? Honest, like that. Well, I thought I might, in that case, especially since I think the material for today, probably not quite fitting 40 minutes, should just give you like a very quick overview. So, of this one. Sorry, not this one, this one. This one. So, step back for a moment. Remember, 3 main grounds of judicial review: illegality, procedural impropriety, irrationality, previously known as Wednesbury unreasonableness. Okay, the first 2 lectures covered illegality, including nearly a whole lecture on breach of substantive legitimate expectations, which is probably best classed as an example of abuse of discretion under the illegality head. Second main ground of judicial review is procedural impropriety, okay, of which this lecture is doing part 2. Part 1 is this lecture here. That's the handout for it and there's a recording. So I recommended you to listen to this one, if possible, first, so that this lecture would make sense. Noting that some of you haven't, I will try and give you a 5 to 10 minute summary. So, think of it as all a little tree, right? You've got 3 main grounds of review and then there's little branches off each one. And I broke down illegality for you in the first lecture handout like that. So procedural impropriety falls into 2, okay? The rule against bias. Don't need to write any of this stuff down, it's all in the handout. It's really just to give you an overview so this lecture makes sense. So procedural impropriety breaks down into 2 separate main subsections. The rule against bias and what is generally referred to as the duty to act fairly. The old term being audi alteram partem, here the other side. And for bias, nemo judex in rea sua, which I'm sure the Latin scholars amongst you have at your fingertips, and translated as no one should be a judge in their own case. So, the rule against bias then breaks down in turn into two main subcategories. There is the rule of automatic disqualification, which is a certain narrow category of interests that if a decision maker is found to have them, means that they are automatically disqualified and their decision automatically quashed. And then if it doesn't fall into that narrow category, a broader category of apparent bias, where the test is, where's it gone? There we go. Whether a fair-minded and informed observer, having considered the facts, would conclude there was a real possibility the decision maker was biased. So bias itself, 2 different types. automatic disqualification for a narrow category of specific interests, and the general test for all other cases, which is that test for apparent bias, which is notice to do with a reasonable perception of the possibility of bias, rather than the court investigating whether there was actual bias in the decision maker. The narrow category is, as you can see here, the narrow category of automatic disqualification, so a financial interest in the outcome. Okay, a decision maker, for example, who holds shares in one of the parties to the case before them, so that they have a financial interest in the outcome. That's the traditional grounds for automatic disqualification. I won't go through the cases. The Pinochet case, which is a bit complicated, and you need to look at carefully, added another small type of case to this narrow category of automatic disqualification, which is essentially where you have some association with one of the parties to the case in front of you. This was a case that went to the House of Lords. One of the judges was found to be a director of a branch of Amnesty International, which was intervening in the case, Lord Hoffman. So in other words, the judge was associated with, had a role in one of the parties to the case. So in a sense, he was acting as judge in his own case. It's important to get the narrowness when you read it of the Pinochet category. The financial interest category is an easier one to grasp immediately. Outside that, as I said, this is the test. So it's often referred to as apparent bias. It comes from Porter and McGill, which we looked at. Okay, I'm not going to go through all the detail on the handout and the lecture. Do listen to it for yourselves. But that, in a nutshell, is bias. Okay. So procedural impropriety breaks into two: bias, duty to act fairly. Bias itself breaks into two: automatic disqualification for a narrow category of interests, financial interests, being a judge in your own case, and the broad test for all other cases, which is apparent bias. That test, whether a fair-minded and informed observer, having considered the facts, would conclude there was a real possibility the decision maker was biased. The second branch is the duty to act fairly at common law. So this applies to all decision makers, often things like local authorities, sometimes ministers, sometimes other bodies, all the bodies that the court by judicial review, that the public authorities. And the issue is, if the statute is silent on how they should treat someone who is affected by their decision, does the common law supply some kind of duty to act fairly? And there are various ways of getting at the common law implying some kind of duty to act fairly, which include an impact on someone's legal rights or fundamental freedoms, or an impact on their important interests. Famous case, nice simple case, ex parte Hook, of a man who was banned from holding, he made his living by having a market stall. He was banned for life from it for the offence of peeing in the street. And it was found that there had to be a fair procedure before he was deprived of his licence, since that was his livelihood. And the modern approach is a concept we went through in terms of substantive expectations, but a legitimate expectation of fair procedure. Okay, which can be based on either an express duty, for example, of consultation. So if a council says, for example, to a group of taxi drivers, before we increase the number of taxi licences in the city, as in the Liverpool case, which will affect your livelihoods, we promise we will consult with you. If you then go ahead and make the decision without consulting with the taxi drivers, that's clearly a breach of the express promise of consultation, but it can also arise from past practice, as in the GCHQ case, where there's a consistent practice of consultation before a major change in working conditions. The court will then from that say, well, there's a legitimate expectation that that practice of fair procedure will be continued before decisions are made. Or finally, simply based on previous enjoyment of a benefit, meaning if you've been enjoying something, such as residents living in a care home for the elderly, before it's shut down, before that benefit is removed, you should have some right to participate in the decision through consultation again, generally. Okay. something not afforded to bare applicants. This will all make more sense, obviously, when you go through the lecture. I'm just trying to provide a very brief overview so this lecture makes sense. So those are all the ways in which the court might say, okay, in the absence of any statutory provision, the common law is going to imply some kind of duty of fair procedure on the decision maker. In terms of the content of what that looks like, there's a kind of escalating series of steps. The first of which, most basic, is notice of the case against you. The case against you meaning, essentially, if some decision is going to be made that's adverse to your interests, what is the basis for making the decision? So if you think about you, for example, as a student, if you are being accused of cheating in an assessment, which could have a very serious outcome, namely being thrown out of the university with no degree, then you would expect to have some kind of hearing for that, right? But in order for the hearing to be fair, the evidence against you has to be fully disclosed. Obviously, this is also how criminal and civil trial work. So this is the whole basis of fair procedure. Yeah?
In the Manson House case, when they had
yes, the Coughlin case. Yeah.
Was it? Because my understanding of it was that they could be consulted, but they had nothing. They couldn't change it anyway.
Which case?
The Manson, the one where I can't remember the name of it.
Was that
disabled
Coughlin?
woman and
Coughlin?
she wanted to be consulted. I can't remember.
I think that's the Madison House case.
Coughlin, something like that. The one with the disabled woman and she's got me.
Yes, Coughlin.
Yeah. So it talks about consultation, but does that mean that she could, like that was, she was trying to argue that she wanted the right to be consulted about the change, but could she actually change the decision? Do you know what I mean?
Yes, well she was arguing both, I think. Yeah, so Coughlin was actually, is normally cited as a case of substantive legitimate expectations.
If they'd given her the consultation and decided against it anyway,
yeah,
that would have been completely fine, surely.
So you can have a legitimate expectation of two different things. One is to be consulted before a decision is made. The other is that the actual decision against your interests will not be made at all. And she was arguing the latter.
When you say consulted, does that mean just the right to just say and be told that it was going to happen and have a say in it?
Yeah.
They could still make.
Yes, if it's purely.
You could do even if you were consulted.
If it's only a procedure, yes.
Okay.
That's a procedural case, right? What you're asking for is the right to be consulted. What we went through last week was where you're asking not just the right to be consulted, but for them to actually make a particular decision in your favour, which was what the Coughlin was a case, which was don't close the care home because you promised that it would be a home for life. That's a substantive outcome, okay? In other words, you are promised a particular outcome, namely you will have this home for life, and the public authority is not allowed to go back on that promise unless they have a good public interest justification. This kind of thing, where it's a procedural expectation, is simply a right to be consulted. So yeah, so the council writes to you or whoever it is and says, we are thinking of making this decision, would you like to make representations on it? You see it in really mundane outcomes, so if there's, if there's going to be, if you own a property and there's going to be a development near it that might affect your property values, there will be notices put up, there's little notices on trees that you get, and there's a place you can write in as someone who might be affected by it and give your views on it. Okay, so what you need is notice of the case against you, or the thing that's happening that you might not like. Okay, it can be the case against you if you say you're a student who might be excluded from university. It may just be something happening that you don't want to happen, like this enormous tower block being built next to your house. But you need to know the substance of what is the reason for the thing that may be going to happen, or the reason why you might be excluded from university, or the reason why your license, if you're on parole, might be revoked, or as in one of these last cases, that one, if your parents and your child has been excluded from the school, or is going to be excluded from the school for bad behaviour, then as parents you need to be told why, what is the evidence against your child, because without knowing why, you can't meaningfully make representations in your child's favour. Okay? So that's the lowest element of procedural fairness, is always to be notified of what is happening. What is the thing that's going to happen that's adverse to your interests, so that you have a chance to make representations on it. So that, in a nutshell, is what that lecture covers. Okay, the rule against bias and then the basic building blocks of the duty to act fairly, or the right to procedural fairness. Any questions on that? Ooh. I can. So a legitimate expectation is simply an expectation of either some kind of procedure, like consultation, or a particular outcome in your favour, like not being thrown out of the care home that you were promised for life, that the courts regard as a legitimate one. One that it was reasonable for you to rely on in the circumstances. And it's based on either a promise by the public authority in question, or sometimes on a regular pattern of past practice that generates a procedural expectation. So let's say, which is not the case, the university had no rules on the procedure if it was going to expel a student for cheating. If, however, you knew that in every single case that had ever happened, the university had always held a proper hearing and given the student full notice of the case, and provided them an opportunity to make representations in a full oral hearing, that would generate a reasonable expectation that that would be applied to you. Okay, so an expectation can arise generally through a promise or representation, but sometimes through a regular pattern of past practice. Okay? So, what we're doing is going up the scale from the minimal duty, which is to give someone notice of the case against them, to stage 2, which is, okay, making representations about it. And the question here is, often, is there a right to an oral hearing or merely an ability to make written representations about it, about the decision? Now note, I'll go through this in some detail in the recorded lecture, what the law considers to be bare applicants are often not entitled to any of these procedural steps. So think about it when you applied for a place at university, either for your undergraduate or indeed for this course, you either got a place or you didn't, but universities don't give reasons for that decision. And that's because you're treated as a bare applicant for a benefit. And in general, decision makers don't have to consult with you on the matter or indeed explain the decision to you and allow you to make representations on it before they make a final decision. They just make a decision. Contrast that with having an existing benefit that's going to be taken away from you. So if you are going to be, for example, thrown off your course for some reason, or even if the course was perhaps going to be closed down midway through because the university ran out of money, that would be the kind of thing because you've got an existing benefit and it's being withdrawn from you, where you would expect the chance to make representations and be consulted on it. So this is a really important distinction the law draws between being a bare applicant for a benefit, on the one hand, where you have low or no procedural rights, and being someone who is in possession of a benefit that is going to be taken away from you, where you will generally have procedural rights in relation to it. You will often expect to be consulted before that benefit is withdrawn from you, or at least told about it and given the chance to make representations. So that's that first point. Bare applicants may refuse both unless reputation is in danger. That refers to, again, something you'll see in the previous lecture, the notion that if you apply for something that you would normally expect to get, and the reason you don't get it, in one case this involved British citizenship, where someone appeared to fulfil the criteria, the court found that although they were a bare applicant for a benefit, it looked like the reason they'd been refused it was because they were not of good character, and that was an implied slur on their reputation. So if you apply for a benefit and are refused it in a circumstance that makes it look as if your good name is being called into question, you may be entitled to be given a chance to make representations on that point. Because then you're having something taken away from you, if you like, your reputation. Yes?
Sorry, this isn't a very academic question, but the one about the person who got refused for good character, was that Mohammed Al-Fayed?
That's Al-Fayed, yeah. Yeah, that's from the previous lecture, yeah. Excellent question. So, Now, in terms of the distinction between written representation suffice for the large majority of cases, okay? If the courts have decided, okay, you have a right to behold the case against you, given the chance to make representations on it, then in the vast majority of cases, what you get is to make written representations in writing. But in a few cases of particular importance, you may have the right to an oral hearing. So here's a couple of examples in those cases, Ex parte Harry and Smith versus the Parole Board. So H, there's the facts about Harry. He was a mental patient obtaining conditions of maximum security. Maximum security means obviously minimal liberty. He made an application to be transferred to a lower security mental institution where he'd have considerably more freedom, and that was refused. So it was held that he had to be given the chance to make representations against that decision because of the importance to him of it. Similarly, in Smith and the Parole Board, notice how these cases are both concerned with essentially your fundamental rights, in this case your right to liberty. So Smith and the Parole Board concerned revocation of a prisoner's licence. What that means is prisoners near the end of their sentence are often let out early, provided they're of good behaviour. They don't breach any of their parole conditions, which could include things like not taking drugs, not sometimes seeing particular people, or obviously, in general, abiding by the criminal law. Then your licence can be revoked, and you are then sent back to prison. So the effect of the decision is a little bit like being found guilty of a criminal offence and being sent to prison. So in this case, you're out of prison but on licence. You'll see quite a lot of the cases involve this. But when you're granted licence, or put out on parole, it's subject to certain conditions. If you're found to have breached those conditions, then you're returned to prison. Okay, so in other words, the effect of the decision on you is drastic. You are deprived of your liberty again. And your liberty is obviously a fundamental right recognised by common law and the European Convention. So in this case, the question was, when the parole board made a determination that they had breached their parole conditions, did there have to be an oral hearing or not before the parole board made its determination? So the applicants argued that, look, the effect of this decision by the parole board that we've breached our parole conditions is that we are back in prison. We've lost our liberty. So the decision is of such importance to us that there should be an oral hearing in which all the evidence can be properly heard. We get the chance to make representations about our case before the parole board comes to a decision. Now, the court found that even in the cases of decisions that have that drastic effect upon a person's rights, namely returning them to prison, the parole board isn't always required to hold an oral hearing. And this is the really crucial point about oral hearings, because they can involve things like calling witnesses and cross-examination. There was a fundamental dispute as to the facts of the case. So the question was, had the parole board actually accurately found out what had happened, or was it basing its decision on a perhaps mistaken view of what the people out on parole had done? So in other words, they disputed the factual basis for the parole board's decision. The point of an oral hearing primarily is to allow, just as in a trial, is to allow evidence to be tested through calling witnesses and sometimes through cross-examination of those witnesses. That's the traditional English legal approach to resolving disputes of fact. So the cases where you're likely to get the court saying, okay, the public body should have held an oral hearing before making its decision, is A, where it has a major impact on the applicant. So in general, this case obviously involved them losing their liberty, but it's traditional for universities, for example, to hold oral hearings before before throwing out a student for cheating, because that can have a catastrophic effect on their reputation and their ability to gain employment, as well as depriving them of the benefit of the degree that they paid for. And in particular, where there's some kind of dispute as to the evidence, as to the facts of the case, and the claimant wants to be able to challenge the view of the public body as to what actually happened, and say they need to be able to call witnesses, there needs to be cross-examination of those witnesses to get to the truth of what happened. And if the court thinks that an oral hearing was the only fair way to do that, then it will quash the decision and say, okay, you have to go back and hold an oral hearing before you make your final decision. But it's relatively rarely granted, and it tends to involve those two things together, okay? A major impact on the fundamental interest or rights of the claimant, plus a conflict of factual evidence that can only be resolved, the court thinks, by an oral hearing. The other way, of course, is a right to be heard can be generated by regular past practice or promise. So if a public authority promises to grant an oral hearing or a right to make representations in a particular set of cases, or has a regular past practice of doing so, the courts will generally hold them to that legitimate expectation of that particular procedure which they've granted in the past or have promised to grant. As in my example of a university that had a regular past practice of always holding oral hearings if students were accused of cheating and could face being excluded. Okay, and finally on witnesses and cross-examination, the basic same principle applies. If there is a hearing, and then there's a dispute about what elements the hearing should involve, the court's view is that witnesses, the calling of witnesses and cross-examination of those witnesses should be permitted if there is an important dispute on the fact that seriously affects the rights of the claimant. So in that case, Knowlesley, a doctor faced being effectively barred from practice after allegations of indecently assaulting 4 patients, which is of course also a criminal matter. The court held that there should have been a full oral hearing in which he could test the evidence against him because he was disputing, as a matter of fact, the allegations. Right, let's take a very short break, 2 minutes. Quick comfort break if you like, and then we'll resume and go quickly through the reasons cases.
Yeah, you hold them down.
Yeah, you can do that. I know it looks small, but
Watching.
but so like as I go through it, those bits that I highlighted, it smells like oh, I just did so many mistakes, but half of it was like and then like 2, it was like you could have mentioned this case, and I was like, well, I didn't have words for it.
Were you in Bristol?
In the first place, I didn't remember, but I thought I should do a lot about next because it's relevant.
Apparently it was. Yeah, I feel like I want to argue that too.
Okay, because everyone seems to want to argue that you're not meant to apply next to it, and I was like, okay. I'm really confused.
Too uncertainty.
Because you only have so many words. You can't say, oh,
Righty-ho, folks. So, reasons comes at the end of the decision-making process, okay? This is a ground of challenge where you were saying, once the public body had come to a final decision, whether or not it consulted me, they ought to have given me a set of reasons for the final decision. Okay, so this is not consultation while the decision-making process is still underway, which is the right to make representations. So that's when you want notice of the case against you, you're saying a decision hasn't yet been made, I want the chance to be heard before you make the decision in question. The notice of a duty to give reasons is about a duty to give reasons once a final decision has been made. The public body, the argument is, should give me reasons so that, for example, I can tell that the decision was made correctly or for some other particular feature of the case. So I have to say the case law here is something of a fudge. It's not that easy to make sense of. And in fact, this whole area of procedural fairness can seem kind of frustratingly vague. It's full of kind of vague tests like, does fairness demand this, or is there a legitimate expectation of a fair process? Talk about balancing with other interests, and so on. So the tests themselves are always quite vague. The only real way to kind of get a feel for how it works is to read some of the cases and see how the judges actually reason them through. Okay, but I'll give you the general guidance that I can, but the tests that the courts use do seem somewhat vague and open-ended. Okay, it's not very hard-edged in some cases. So we're talking about cases where obviously if reasons are required by statute for particular decisions, like decisions of tribunals, for example, where they have to give fully reasoned judgments, then you don't need this. This is for cases in which the statute is silent on the matter, but you are asking for the common law to imply a duty to give reasons for a final decision which involves you. Okay, so we're still at the position where there's no general duty implied, as a general rule to give reasons for administrative decisions, but there will be in particular cases. Stefan, in a case by the Privy Council in Stefan, they looked as if they were ready to flip that over and say, well, actually, we're now in a position where generally that you should give reasons unless there's a particular exception where you shouldn't, but the courts have kind of toyed with that idea and never quite got there. So in the latest cases, they're still basically saying, no, where we're at is there's no overall duty to give reasons, you have to point to a particular feature of the case to get them. And the reasons why you might are similar in some ways to the general factors that the courts use when deciding on procedural fairness. So, two categories of cases. First is if the decision impacts on what the courts regard as your highly regarded rights or interests, including legal rights or fundamental interests, like having your stall taken away from you that you depend on to make your living, or being thrown off a university course, which will have a massive impact on your life, okay? So there's one category which is basically, you get reasons because the decision is just of such significance for you that fairness requires that the decision be explained to you before it happens. Second category of cases, if that doesn't apply, you can still get reasons if there is some other feature of the decision-making process, often which indicates the decision, something may have gone wrong with the decision-making process, because, for example, it goes against what you could reasonably have expected, or there was a conflict of factual evidence and it's not clear what view of it the decision-maker took, something like that. As you'll see, some of the latest planning cases involve instances where there was a major planning decision by a council to be made and they went against the recommendation of their expert planning committee. Okay, so two category cases where just the nature of the impact of the decision on the individual is such that fairness requires that reasons be given. The other is, if it looks as if there's something odd about the decision in itself, reasons should be given so the claimant can be sure that something hasn't gone wrong with the decision-making process, such as, for example, failing to have regard to relevant matters or having regard to irrelevant ones, going against your published policies, that kind of thing. So, again, in the highly regarded interest category, this is the case of the sentence that should be given to prisoners. Yet another challenge that arose from the old practice where the Home Secretary set the sentences for people who had committed a life offence, an offence for which you get life in prison. so many of these cases, which eventually resulted in this being taken away from the Home Secretary and being given to the judiciary where it probably belonged, because Home Secretaries kept running into problems when they were making these decisions, and the courts finding they hadn't actually acted properly in doing so. So in this case, if you get a life sentence, obviously I hope this will never happen to you, it's divided into two elements. So the first is the penal element. That's the part of the sentence which is for punishment and deterrence of others. So that's a fixed amount, often called the tariff. So it might be, for example, 15 years. So you have to serve, that's the minimum period of time that you then have to serve. Once you finish the tariff element, you are then in principle maybe eligible for parole. You go before the parole board and that decides, essentially, is it safe to release you or not? So they have to make an assessment as to whether, if released, you will re-offend, which unfortunately they often get wrong because it involves predicting human behaviour. If they think that you're not safe, you then have to serve further period of years, months or years, until the parole board decides that you are safe, or as it will often be called, rehabilitated, such that you're not just going to go back and do the same thing again. Okay, so this was about the Home Secretary determining the tariff period, the fixed amount of time that the prisoners had to serve for the purposes of punishment, determined the penal period without consulting the prisoners, informed them of it, and didn't give them any reasons. And the court found, how it went to the House of Lords, and they found that essentially the importance of the decision to the prisoner, how long will you have to spend in prison, was such that fairness required that reasons be given for it. And that's partly because if you look at the court's ground A, that slightly conflates reasons with representations, but I think the idea was that even after you'd made the decisions, even after you'd made the decision on the penal element, if they had reasons, they could make further representations on, and hope that you might take them into account. Fairness, and this one that you see constantly, which the courts refer to in many cases, without reasons, the prisoner has no means of ascertaining whether this is an instance where the decision-making process has gone astray. In other words, if you have reasons for a decision, you can then look at them and think, okay, can I tell from these that decision-makers actually made it properly by, for example, having regard to relevant matters, disregarding irrelevant matters, not acting for an improper purpose, and so on. Known as the springboard reason, because the springboard rationale, the springboard because it may give you, hearing the reasons for a decision may give you a way of ascertaining that something has gone wrong, and you can therefore challenge it on judicial review. Okay, so that category of cases, as you can see from the example of Doody, is where the impact on the individual is so severe that the courts think fairness requires that they get reasons for the decision. Obviously that is a fairly vague and woolly category, clearly applied in the case of knowing your prison sentence, which relates to your right to liberty. As I said, in the second category of cases is where it doesn't fall into that. You can't, the courts find, well, okay, this isn't important to you, but it doesn't fall into the highly regarded interest category. Can you point to some feature, some particular feature of this decision that shows why you should be given the reasons for it, or you should have been given the reasons for it? And there are some examples here. So all the available evidence seems to point the other way. These are all instances in which the decision appears inexplicable or dubious or unreasonable. Something looks odd or wrong about the decision. So that could come about because all the available evidence appears to point the other way, and yet the decision maker still came up with the decision that they did. It's substantially different from that which the applicant reasonably expected, as in Matson. There was a conflict of factual evidence, and it appears the decision maker must have regarded some evidence and disregarded others, or regarded some evidence as credible and others as not, but it's not clear how or why they reached their decision.
What would a conflict of interest come under?
Where's the conflict of interest bit? Oh. As in, which could mean the decision maker may have been biased. Yeah.
Come under bias?
Well, that would come under the rule of bias if you knew about it already, yes. You could just challenge it if there was, yeah.
So if, like, say, if like, clearly the board were discriminatory against you, would that be under bias?
Yes. Well, if it appeared that they had, I mean, if they haven't given any reasons, then the point is you don't know exactly why they have made the decision that they do.
It appears from
But it
the way
appears
that the
that would be an
proceedings have
example.
gone that they might have been a bit
Yeah.
discriminatory or whatever against you.
Yeah,
That would also be under
that
bias.
kind of thing. Yeah.
Okay.
If you were just talking about judicial review being the review of last resort, sometimes there's other remedies. If there's a statutory remedy, such as a right of appeal, then you may require reasons in order to be able to ascertain whether you have reasonable grounds to launch an appeal, as in the Stefan case. So just to give you a couple, to close, give you a couple of examples of decisions in that second category. Okay, so planning decisions, big planning decisions by local authorities. In general, local authorities don't have a duty to give reasons for planning decisions, partly as a matter of resources. But these were instances where the courts found exception that they should. So the Oakley case, you can see the facts there. There was an application to build a football stadium on what's called the Green Belt, which is the area of countryside in England that is generally given extra protection against planning developments like housing and so on. So the planning officer had recommended refusing. Planning officer is the planning officers employed by councils, give them expert advice on planning decisions. Planning officer had recommended they refuse this application to build a football stadium on the Greenbelt. Unexpectedly, the council rejected that advice and gave planning permission. And it gave no reasons for doing so. And there were obviously various people who'd objected to permission being granted precisely because it was building on the Greenbelt. Okay. So, in this case, the Court of Appeal found that reasons should have been given, and they offered a variety of reasons. So, the first one you're familiar with, it appears out of line, said Lord Justice Sales, with the natural and reasonable expectations on part of the public. The decisions will comply with the local plan and with national policy to protect the Greenbelt. And then Elias, Lord Justice Elias, gives a general set of reasons why, in general, it's desirable. As you can see there. So those are to do with the notion of supervising, allowing the courts to supervise the decision. In other words, allowing people to have reasons, because then they can see if something has gone wrong with the decision-making process and can thereby challenge it on judicial review. The problem with that factor is, of course, it could apply to every single administrative decision. So every decision, if you get the reasons for it, you're able to find out whether something has gone wrong with the decision-making process because you read the reasons. You can ascertain, okay, have they done something they shouldn't? Have they approached this? Have they had a conflict of interest? So the courts constantly return to this factor, but are aware that they can't say that that's the factor on its own. Otherwise, that would be a reason. That would be a ground for requiring that reasons always be given for all public law decisions, which they're not yet at. So Lord Justice Elias focuses on that, but he notes, he singles out this one, where third parties have taken an active part by making representations. So in this case, because it was controversial to have a major development on the Greenbelt, lots of third parties have written to the council trying to say, please don't give permission for this, it'll ruin the countryside. And one of the reasons given was that the fact that they had intervened in the process as a third party, making representations, fairness required them to be told, okay, this is why your representations were rejected, and the decision went ahead. But I think the most important reason for it is simply that the decision was out of line with what could reasonably have been expected. And it's unusual for a council to reject the expert advice of its planning officers and give permission for a major development, which in this case was on the Greenbelt and was against the local development plan. So it's a classic example of where the decision was not what would reasonably or normally have been expected. And therefore reasons had to be given to ascertain whether the council essentially had gone about the decision-making process properly. Because if not, you could then challenge it on judicial review. And a similar case, Dover District Council, in this case, permission for development in an area of outstanding natural beauty, again, against the advice of its professional planning advisors. Didn't set out the main reasons for the decision. And there's some nice, this is a case that I recommend you read, is giving you a feel. This is a recent case in the Supreme Court, is giving you a feel for how the courts approach this kind of thing. So having given this reason, about my reason giving is generally desirable because it allows people to have confidence in the process, to find out if something might have gone wrong so they can challenge it. He then adds the specific rationale applying in this particular case where planning permission has been granted in the face of substantial public opposition and against the advice of planning officers. Okay, so again, that's the same kind of case as Oakley. The decision wasn't what you reasonably expect. It's controversial. There's been a lot of public opposition. People have written in urging the council not to do it. In that kind of case, as opposed to just a routine planning case, fairness and ensuring that people can work out why the decision was made as it was and whether anything's gone wrong with it requires that reasons be given.
How long after a decision is made can you judicially, is it unlimited, like you could do
No,
something?
no, no, it's within the strict judicial review time limit, which is generally 3 months.
Is that statutory?
Yeah. That's in all the procedural stuff around judicial review, which we'll look at in the next learning cycle. But yeah, there are strict time limits, only 3 months is the general one. So yeah.
Any decision?
For any decision, yeah. It can exceptionally be extended, but it's a fairly strict time limit. Much shorter than for tort or contract, which is 6 years, I think, the limitation period. Okay, this is the most recent case I found, or one of the most recent cases I found, which shows that we are still at the same thing we were at Doody, that there isn't a general common law duty to give reasons for administrative decisions. The fact that reasons might enable public law errors to be detected and make the judiciary more effective is not a sufficient justification because it would apply in every single case. So you still have to have some other factor, okay? Either the highly regarded interest category, it impacts on your fundamental rights or interests, or there's something odd-looking or strange or unexpected about the decision. And those are just instances where the courts found that reasons didn't have to be given. Refusal of a discretionary grant is a bit like refusal of a discretionary place at a university or issues of academic judgment. In the Higher Education Funding Council case, where the court found that that kind of academic judgment was not reducible to that reason, which is actually a bit doubtful, but that was quite an early case. Okay, so that statement in Greenpeace is still where we are, which means we are still in those two categories. So if it comes up in a problem question, you have to try and figure out, can I put it into one of the two categories where reasons have to be given, and identify, using analogies from the case law, why it falls into the type of category where the court would say exceptionally reasons do have to be given, should have been given for this particular decision. Right, thank you very much. Enjoy, well, I will see you in your seminars next week. Please, please, please do the prep work. For the group who has tomorrow at 2 o'clock, I expect to get your little outline answers, just a paragraph this afternoon. It will give you an enormous amount of help with tackling the problem questions of the type that your second summative is.
I actually texted him like last week and was like, have you dropped out? And then apparently I'm not gonna lie, like he's gonna last very long if he's not coming. I haven't seen him in
Definitely haven't seen him this year.
We were just talking about that we hadn't
How
seen.
did you do that?
That was so weird. I was like, I haven't seen him in a month. I don't know. I think he said he'd throw it.
Are we doing the thing where well, I'd say that I don't agree at anything.
No, Wednesday.
Tomorrow.
Is it in tomorrow?
2 o'clock.
Okay, yeah, yeah. Okay, sure, yeah.